All right, you're Giovanni Coleman.
Yes, sir.
This is cause number 25 DCCR 0479. Mr. Coleman is charged with the first-degree felony offense of murder. And what is the the announcement?
Judge, we are very, very close to an agreement that will resolve this case without a trial. There are some technicalities that need to be worked out and need to be approved by various people. I think Ms. Malfino will agree with that assessment. But we believe this is going to get resolved. Mr. Coleman agrees in principle with the deal that we have worked out. So,
Speak up.
I'm sorry. Mr. Coleman agrees in principle with the deal that we have. And so we're asking for it.
And Judge, if I may, I just put my spin on that.
Please.
And
here's
I would
my
not
concern.
strongly say that we have an agreement in place. It's not like we're waiting for the ink to dry. I think what we're saying without saying it so much is that we have had a very productive conversation, which a lot of times in these self-elevated first-degree cases, we're not even able to get to that point. I'm not in a position to make the offer that we have discussed. And if that requires me placing it on the trial docket, knowing that I need to come to the court in advance, if that offer does make itself
Here's what we're going to do.
doable.
You've been on since last May. So we're 14 months into your representation. Last reset, figure out what you need to figure out to whatever the offer is, it is. I want a final offer, yes or no to take it or not. And then if it goes on the trial docket, all of that needs to take place between now and that next announcement.
Okay, we're ready.
This will be the last one. Okay? All right, you go back with the bailiff. Good morning. Are you Arlington Wood Jr.? And Mr. Wood, in cause number 25, DCCR 1650, you're charged with the third-degree felony offense of failure to comply with sex offender registration requirements. That's from July 30th of 2025. The indictment alleges that you were also previously convicted of burglary of a vehicle, a third degree, burglary of a building, a second degree, another burglary of a vehicle, third degree, and an unauthorized use of a motor vehicle, a third degree, on January 27th of 1986. And after those were final, you were convicted of theft, a third degree, January 22nd of 2019. You guys have marked off second degree, but would it not be a habitual?
It's not habitual because
It could be because they did not include in the indictment the underlying sexual assault offense that caused him to have to register.
Okay. So
That would be a notice I would make
a
on
notice,
my own.
and that would make it a habitual, correct? So, Mr. Wood, I want to make sure you understand that if you go to trial and you're found guilty and the state files that notice of enhancement with the prior felony conviction that's not in this indictment, that you could be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Richmond.
And I have a plea bargain rejection here on the tablet that you've signed with Mr. Parker that shows that the district attorney's office has made an offer. If you wanted to enter a plea of guilty, looks like to go forward probably on count one only for a 10-year term in prison. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. Do you understand all of that? Sorry?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Is there any reason to believe that that offer would change, Ms. French?
Mr. Parker may have information for me that might cause that offer to change. Can we reset? How long, Mr. Parker? What do you say?
I mean, I don't know what I'm going to provide you other than what I've told you. I'm not going to have any documentation. I mean, he's on parole, Judge. He has two types of cancer. He has some health issues, and like bluntly, anytime he gets, he thinks it's a death sentence, and so I mean that's his position. Understand it, but I don't know if his position is going to change.
So let's just do this. So, Mr. Wood, I'm going to place your case on the trial docket. If anything changes between now and then, the attorneys can let me know. We can get you back in here sooner. Mr. Parker has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Mr. Parker, you're released. Mr. Wood, we will appoint someone today. They should be out there to see you very soon to begin preparation for trial. Good morning, sir. Are you Pedro Martinez?
Yes, ma'am.
And this is cause number 26, DCCR 1085. Mr. Martinez is charged with assault, family violence by impeding breath or circulation. Mr. Rojas, what is the announcement?
Judge, if I may, have a name called and document a few things for the court's record.
Sure.
The name of the complainant is Margaret Samano.
Margaret Samano.
Margaret Samano. Margaret Samano. On, John.
Judge, may the record reflect that the complainant, Ms. Samano, has not appeared in court today. We're not surprised by that. I did make every attempt to reach out to her at known information I also asked my family violence investigator, Ms. Guidry, to reach out to her. It's apparent to us, from one, she non-prosecuted, so to speak, in the offense material, and two, I don't believe she has a permanent residence, and they have attempted to track her at some known locations for people who don't have a stable place to reside, unable to do so. We did find one email to her at a Gmail account. We made every attempt to send notification there to please contact us, both in English and in Spanish. She has yet to respond, Judge. Obviously, the nature of the offense is concerning with it being a family violence, but on the other hand, the fact that the defendant has been in custody, I feel with that information, it is my duty to, at this time, move to dismiss, and if further information comes to light, I will bring it to the court's attention.
Okay, then I'll sign that. Obviously, Mr. Martinez, I'm taking a look now at that probable cause affidavit. So something went on that night that shouldn't have gone on. And the fact that she isn't cooperating makes me very concerned, but it is what it is. If you end up back in here, or if she changes her mind, they could re-indict your case, but whatever was going on you need to stay far, far away from that.
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you, Justin.
I'll sign it as soon as it comes through. Good morning. Are you Jamie Story?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Story, in cause number 23, DCCR 1546, I have a motion to revoke your community supervision. Shows that you were placed on probation February 25th of 2025 for the state jail felony offense of theft of property with previous convictions, and that was enhanced to a third-degree felony because of some prior felony offenses. And it looks like the punishment was assessed at 10 years with a 10-year probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to report to the probation department January 29th, February 12th, and February 26th of 2026. And is that true or not true?
No.
True or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your contact information. And is that true or not true?
True.
Count 4 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
True.
Count 5 alleges that you failed to complete the mental health assessment and follow all of those recommendations. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
And finally, count 7 alleges that you're behind in your court assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've made is for a cap of 6 years in prison, which means if I follow that agreement, I can give you 6, I can give you less than 6. It'll all depend on the information that's brought to me when we come back for a sentencing hearing. And is that what you want me to do?
Yes, ma'am.
All right, state tender's number 1.
Objection.
It's admitted any evidence Ms. Story is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing so that the probation department can do an updated report. Also, anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when we come back. All right, you can go back with the baby.
Great, thank you.